Section 23, Legal Hotline, Q&A, Part 5, Today's Fair Housing Rules and Regulations, 2026, Standard. Introduction, When Disclosure, Ethics, and the Law Collide. As we move into this final legal hotline section, everything you've learned throughout the course comes together: fair housing, disclosure, advertising, agency, and professional responsibility. This section builds directly on Sections 17 and 19, where we explored access, violations, and enforcement. Now we focus on one of the most complex and misunderstood areas in real estate: what must be disclosed, what cannot be disclosed, and what falls in between. In 2026, many fair housing issues are not about refusing housing. They are about what information is shared, withheld, or misrepresented during a transaction. The difference between compliance and violation often comes down to knowing exactly where that legal line is. Scenario 1. Homicide in the property. Stigmatized property. Let's start with one of the most common questions agents get. A seller tells the listing agent that a murder occurred in the home and asks that it not be disclosed. Does the agent have to disclose it? No. Under Arizona law, there is no liability for failing to disclose that a property was the site of a homicide, suicide, or natural death. This falls under what is known as a stigmatized property. Now here's where it gets tricky. If a buyer directly asks about deaths in the home, the agent is still not required to answer. However, if the agent chooses to respond, they must be truthful and cannot mislead the buyer. 2026 Rule: You are not required to disclose, but you cannot lie. This ties directly back to Section 7 and Section 19. Honesty and accuracy are always required. Scenario 2. Nearby nudist colony, material fact disclosure. Now let's flip the situation. A seller informs the agent that there is a nudist colony nearby, and that individuals from the colony can sometimes be seen from the property. The seller asks the agent to keep this confidential. Can the agent stay silent? No. This is considered a material fact that may affect the buyer's decision to purchase the property. Under Arizona Administrative Code R428-1101, agents are required to disclose all known material facts, even if the seller objects key takeaway. When information impacts value or desirability, it must be disclosed. Best practice: encourage the seller to disclose first, but if they refuse, the agent must still comply with the law. Scenario 3. Financing misrepresentation in MLS. A listing agent advertises a condominium as eligible for conventional financing. However, the agent later learns that due to ownership concentration, the property may not qualify for conventional loans. Does the agent have to update the listing? Yes. Agents must ensure that all advertising is accurate and does not create misleading impressions. Under AAC R428-1101 and R428-502, failure to disclose known financing limitations is a violation. 2026 Insight: Advertising is not just marketing, it is a legal representation of the property. Best practice use language such as, property may not qualify for all conventional financing, buyer to verify. This protects both the agent and the consumer. Scenario 4. Disclosure of relationship to seller. Conflict of interest. An agent is listing a property owned by her brother-in-law. Does she need to disclose the relationship? Yes. Under Arizona law, agents must disclose any present or prospective interest in a transaction, including relationships with immediate family members. This disclosure must be made in writing and before entering into any binding agreement. This ties directly back to agency law and fiduciary duty. 2026. Rule: transparency is not optional, it is required. Scenario 5. Natural death in the home. A seller's father passed away in the home, and the property is now being sold. Is disclosure required? No. Again, under ARS, paragraph 32-2156, there is no obligation to disclose natural deaths in a property. However, just like in the homicide scenario, if asked, the agent must not misrepresent the facts. This reinforces the same principle. No duty to disclose, but a duty to be truthful. Scenario 6. Can a broker disclose anyway? Now let's take it one step further. A listing broker tells the buyer's broker that a suicide occurred in the property and insists that the information cannot be shared with the buyer. Is the buyer's broker allowed to disclose it? Yes. While the law protects agents from liability for failing to disclose stigmatized property, it does not prohibit disclosure. There is no law preventing an agent from sharing that information if they choose to do so. 2026 Insight: The law protects against liability. it does not create a gag order. The pattern. Understanding disclosure boundaries. At this level, you should clearly see the distinction between what must be disclosed, material facts affecting value or desirability, known defects or limitations, conflicts of interest, what is not required to be disclosed, deaths in the property, stigmatized events, what can never be done, misrepresent facts, provide misleading information, withhold material facts. This ties directly back to multiple sections in the course. Section 3, Subtle Forms of Discrimination. Section 15, Advertising Accuracy. Section 19, Violations and Enforcement, bringing it all together, the 2026 Disclosure Standard. In today's real estate environment, disclosure is one of the most important responsibilities you have as a professional. You are expected to know what is material, understand what is protected, communicate clearly and truthfully, balance legal obligations with client expectations. Because in 2026, the biggest risks are not always obvious. They happen when agents stay silent when they should speak, agents speak when they should stay neutral, agents guess instead of relying on the law. The most successful professionals are those who understand that disclosure is not just about information, it is about protecting the integrity of the transaction. Online discussion. Question 1. What is the difference between a material fact and a stigmatized property? Answer. A material fact affects the value or desirability of a property and must be disclosed, while stigmatized property, such as a death, does not require disclosure. Question 2. When must an agent disclose a relationship with the seller? Answer. Before entering into any binding agreement and in writing. Question 3. Can an agent disclose a death in a property if they choose to? Answer. Yes, as long as the information is truthful and not misleading.